So should I stand during this or does it matter?
It's your preference.
Oh, okay.
Hear ye, hear ye, hear ye. Court of Appeals for the 14th District of Texas now in session. Pursuant to adjournment. God save the Constitution and His honorable court.
Good afternoon, everyone, and welcome to the 14th Court of Appeals. We have two cases set for submission today on our docket. The first is number 20544CV, Bachtel Enterprises, LLC, and others versus Anchor E&P Holdings Corporation. Ms. Pfeiffer, are you ready to proceed?
Yes, Your Honor, and I'm reserving 5 minutes for rebuttal.
Okay, thank you. And Mr. Johnson, are you ready?
I am, Your Honor.
All right. And then the second case is number 21133CR, the state of Texas versus Larry Lausch. Mr. Curry, are you ready to proceed?
Yes, Your Honor. I'm also reserving 5 minutes.
All right, very good. And Mr. Russell, you're prepared?
Yes, Your Honor. Right.
All right. So for the second case, we'll hear the civil case first. And so the attorneys for the second case, we will put you in the waiting room here in a moment, and then we'll come back to you when the first case is done.
Okay.
All right. Before we begin, Ms. Pfeiffer and Mr. Johnson, can both of you see the timer on your screen?
I can, Your Honor.
Okay. All right. Very good. Then we are ready to proceed in Bachtel versus Anchor. So whenever you're ready, Ms. Pfeiffer.
Thank you. May it please the court. The jury found that Anchor breached its contracts by passing along charges to the non-operators without their consent. And the jury found that Anchor breached first. So Anchor has not challenged either of these findings, and the judgment should have been in favor of the non-operators. But the trial court erred during judgment formation by misapplying key provisions of the JOA. And that's where I'd like to spend our time today, by making 3 points. First, that the exculpatory clause in a JOA provides an operator with a defense to losses and liabilities. It does not allow an operator to sign up for contract liabilities without getting the consent of the non-operators and then impose its own contract liabilities on them. The exculpatory clause has no application in a case like this whatsoever. Now, second, the court could skip that threshold question about the exculpatory clause and jump straight to willful misconduct. And the court could hold that the non-operators conclusively established that Anchor acted with willful misconduct. Third, the non-operators conclusively proved that they objected to Anchor's improper charges by making written exceptions. These issues are the most straightforward path to reversing and rendering the judgment. And if I could start with just a couple of key points about the facts, because this is a rather complex case, but it's important to understand the non-operator-operator relationship. JOAs are set up to give operators all the control over drilling operations, except when it comes to spending money. The non-operators are the parties that bring the money to the project. And so the JOA is set up so that the non-operators have the right to consent to every expense before it's incurred. But in this case, the operator, Anchor, did something truly egregious by entering into a contract with a third party to construct a very expensive gas processing plant without their consent. And then it started passing along the costs to the non-operators by deducting it from their revenues. Normally, you would put this on the expense portion of a JIB, but they just deducted it out of their revenues and passed these costs along to the non-operators. Anchor got their consent for 3 specific costs totaling $385,000, but then it never got their consent to go forward with the full gas processing plant and incur all of these expenses. So that's what this case is about. And Anchor has no answer to our threshold point about the application of the exculpatory clause. Our brief leads with the argument at pages 34 through 39 that an exculpatory clause in a JOA has no application whatsoever in a case like this, where the liability at issue is Anchor's contractual liability that it is trying to shift to the non-operators. This makes the factual posture of this case totally different from most cases you'll see that have operators and non-operators. It's very unique because in this case, the operator is trying to shift its own contract liability to non-operators rather than the other way around, where you're looking at how do all the parties bear liabilities generally.
Ms. Pfeiffer, what was different about the Reader case that's different from this circumstance we have here?
Sure. So the Reader case is frankly not very helpful to either side in this case because it's not really answering the question about what kinds of breaches an exculpatory clause would apply to. But as a threshold matter, the court doesn't even have to get into Reader and cases like that where they're analyzing the scope of an exculpatory clause because the liability at issue in this case is Anchor's liability. So you're not looking at an operator using the exculpatory clause as a defense to liability in our case. You're looking at an operator trying to shift its own liability to other parties. Now, if the court wanted to get into scope and line drawing questions, which I don't think you have to do, you could decide it on this threshold issue. But if you get into line drawing questions about operations and activities and how far do exculpatory clauses go in a contract, the Reader case does not hold that an exculpatory clause applies to every last breach under a JOA. What the Reader case holds is that the new model form, which is like the one in this case, uses the word activities to describe the standard of conduct for an operator, and that activities is broader than the old form that used the word operations. But look at the breach at issue in Reader. The breach at issue in Reader was the operator failed to maintain production and paying quantities, which is operations, which is why the parties in Reader were calling the breach an operational breach and saying the court doesn't have to get into interpretive questions about what does activities mean. This case is far easier for this court because even if you want to get into questions about the scope of an exculpatory clause, you can easily hold that it doesn't apply to every last provision under a JOA because there's some JOA provisions that don't relate to operations or activities relating to operations at all, like accounting, like getting consent before incurring charges. So I think the best case for understanding this scope issue and understanding what kinds of breaches would not be at issue for an exculpatory clause is the 10th Circuit case that we cited to the court called Shell Rocky Mountain. And that gives a very full analysis about why not every breach under a JOA would be captured by an exculpatory clause. So I just want to make it crystal clear, though, the court could either say it doesn't apply at all because the liability at issue is the operator's liability, and Anchor has not answered that argument. Listen to them today to see if they'll provide any kind of answer, but in their briefing, they did not. Or the court could just say that the exculpatory clause doesn't reach every last provision of a JOA, and the breach at issue in this case was failure to get consent before charging the operators for an expense, and that's not the type of breach under a JOA to which an exculpatory clause would apply. Remember, this is kind of a risk balancing, an exculpatory clause is a risk balancing provision that ensures that operators are not subject to extraordinary risks like well blowouts or oil spills or the kinds of huge liabilities that operators might face because of the risky nature of what they're doing. It has no application when the breach at issue is failure to get consent for a contract liability. So now turning to willful misconduct, I think that perhaps is the more straightforward way of coming at this case, is the court could simply look to its most recent opinion in Apache that was just decided this summer, and Justice Julie, you were on the panel, where the court defined willful misconduct as deliberate mismanagement committed without regard for consequences. We've given the court a bench exhibit at tab C that outlines both the definition that was improperly used in the jury charge in this case, where it was defined as either malice or gross negligence. We've given the court this court's recent definition. And by the way, while that case is up in the Texas Supreme Court right now on petition briefs, neither side is challenging the definition that this court gave for willful misconduct. So that is a stable definition. And frankly, it's a sensible definition that the industry needed because courts were erroneously saying that it's equivalent to gross negligence, and that doesn't make any sense. So this court's definition is right and it's not being challenged.
I understand your point, but I have a question about that because your brief seems to be applying a sufficiency analysis to our definition we said in Apache, but you didn't request that, or your clients didn't request that in the trial court to be included in the charge. As I recall, the objection was to including any definition of willful misconduct. Is that right?
No, not exactly.
Okay.
The charge objection was objecting to the improper definition that was given, which was malice and gross negligence.
Okay.
And under Texas law, no court had ever said anything like this court did in Apache. So we didn't have an alternative instruction, but we were absolutely telling the judge that it is not a tort-like standard.
All right. So ordinarily, we apply sufficiency review to the definitions and instructions that are given in the charge. And here, if your clients did not request an alternate definition that is along the lines of what we said in Apache, then how can we apply the sufficiency analysis to that test that you're advocating as opposed to applying it to what the definition was given in the charge?
All the court needs to do is hold the definition in the charge was erroneous and then pretend the charge had no definition at all. You would apply the law. So if you disregard the definition that was erroneous and properly objected to, then you look at what is the state of the law, what is the legal standard. Whether the jury was given the legal standard or not, you don't have to consider that. You consider what is the legal standard and apply the evidence. And as the court will see at tab C, where we've marshaled the evidence, we conclusively established that Anchor knew what it was doing without consent and did so without regard for the consequences, which squarely fits this court's definition of willful misconduct. Thank you.
Okay. Thank you, Ms. Pfeiffer. We'll hear from you on rebuttal. Mr. Johnson, we're ready when you are.
Yes, Your Honor. Millard Johnson on behalf of Anchor E&P Holdings Corporation. I'm frankly a little bit surprised by the approach taken by counsel. The scope of the exculpation clause is at the center of this particular appeal. The fact is that the court charged the jury on the basis of the Reader decision. That decision was the gold standard. It was black letter law in the state of Texas and remains so. And so the court was presented with a jury charge that adequately and appropriately charged the jury on the issue of willful misconduct. And the fact is that the jury found that Anchor did not act with willful misconduct. The result of that was the court, and counsel complains that we did not object to disregard any findings. We didn't need to. Once the court found no willful misconduct under Reader, the Anchor was exculpated from liability for any breach related to activities. The Reader decision makes clear, and just as in Reader, this case revolves around the interpretation of 14 joint operating agreements that read identically. They were bargained for. They were heavily negotiated. The original form was the 1982 form. It was negotiated between Renaissance, Anchor's predecessor in interest, and Stephen Kraft, the principal of the majority, all the Kraft appellants in this action. And in that 1982 form, it was amended to add the 1989 exculpation provision. And that 1989 exculpation provision is in tab A of our bench book. And it reads clearly, it, meaning the operator, shall have no liability as operator to the other parties for losses sustained or liabilities incurred, full stop, and except such as may result from willful misconduct. Non-operators agree to indemnify, defend, and hold operator harmless from and against all losses sustained or liabilities incurred in the operation of the contract area, except such as may result from operators' gross negligence or willful misconduct. That's precisely what happened in Reader. the 1989 form was utilized, and the Supreme Court's findings in Reader about the scope of the exculpation clause is the law, and it applies to all activities in connection with the operator's conduct on the project. In this particular case, they've morphed this into, well, Anchor signed up for the liability on the gas plant. It's just not true. It's just not true. First of all, consent is a red herring here. Appellants did not obtain a finding on whether or not there was consent. None of the claims Anchor had required us to obtain a jury finding on consent. If the appellants felt that consent was so critically important, it should have submitted that instruction. It didn't do so, did not request a finding on consent. But even if they had, it would have been abrogated. It would have been vitiated by the jury's finding that there was no willful misconduct. At that point, and this is critical, Reader goes to the breach. I'll quote to the court, the parties agreed by the language of the JOA that liability for a failure to perform contractual obligations requires more than a mere breach. It requires a breach attended by gross negligence or willful misconduct. So when the court chose to charge the jury, it was appropriate to charge it in the way it did. We charged the jury under Reader. We charged the jury under the pattern jury charges 14 months before Apache came out. That's exactly how they should have been charged. And the standard that we utilized, if the court doesn't like the charge, the definition, it should look closely at it, because the standard on the lowest level of the charge as presented in Anchor in this case requires them to jump. Let me back up. The Apache standard requires deliberate conduct on the part of the party. Let's say you have to jump 3 feet. The charge presented in this case was much lower. It said it related solely to subjective awareness of the conduct. That's a 2-foot bar. The jury found the appellants didn't reach the 2-foot bar. They clearly if we had benefit of Apache 14 months later, they wouldn't have cleared the 3-foot bar either. It cannot be an abuse of discretion to charge the jury according to the controlling case law in the state of Texas. And it further cannot be a abuse of discretion for the court to fail to charge a jury on a case that was going to come out 14 months after the jury charge was submitted. So this is a red herring. Besides that, this issue of consent, Anchor conclusively established that these parties consented to the gas plant. I would direct the court's attention to tabs B, C, and D of our amended bench book, particularly if you look at tab D, it says, please make an election to participate in the acquisition of the site and right-of-ways and participation in the gas processing plant. And I quote that precisely. Tab D is the signature of Wolf Rudman, the predecessor in interest of Bachtel Enterprises. Tab C reads exactly the same and is the signature of Michael Pickens on behalf of Pickens Financial, which subsequently assigned its interest to appellant Yazoo Enterprises, which is still closely held and controlled by Mr. Pickens. And tab B, critically important. Tab B is critically important because it shows the consent form signed by Stephen Kraft on behalf of all of the Kraft appellants. And it says, as the others, please make an election to participate in the acquisition of the site and right-of-ways and participation in the gas processing plant. Now,
Counselor, I have a question about that. So
Yes, ma'am.
Under tab D, it says, please make an election to participate in the acquisition of the site and right-of-ways and participation in the gas processing plant within 10 working days from receipt of
Yes.
the letter.
Yes.
But then the consent form that is Xed by the various parties that you reference in your, under your tabs, under your amended oral argument bench book, it says we hereby elect to participate in the gas site acquisition, gas plant right-of-way, and associated engineering costs. So
Yes,
are
ma'am.
you saying that the election to participate in the gas site acquisition, the right-of-way, and the associated engineering costs are the same as participation in the gas processing plant?
Yes, ma'am. And here's why. The gas processing plant, the items checked off on are the items required to be capitalized. These are capital expenses. In other words, Anchor was going to be spending money for which these parties were going to have to pay their proportionate share of the initial expenditures. The gas plant itself was negotiated separately with a company called CDM Max, now called Plains. And that's crucial because it explained, there's an April 2011 memo that explains exactly the financing of that arrangement. So this was for participation in the gas plant. That's what we stated. We got them to check off on the capital expenditures they're going to be charged against their capital account. No capital expenditures were made for the construction of the gas plant. I'll repeat that. None were made. The reason is, if you look at tab I, the Wallace gas plant memo accompanying the 3 AFEs, in this, appellants presented in their bench book, tab E, a version of this memo, a complete version of this memo, but they had an ellipses on the first page. And the first page ellipses left out crucial information that explains this transaction. It reads, and I don't want to spend all my time reading this, but it says basically the plant site will be purchased by Anchor EMP, and this is in tab I, as operator for the joint account. That was a memo in 2011 to everyone, including the appellants. It goes on to read, and will be leased to CDM Max. CDM Max will operate the gas plant under business terms that allow it to recover its capital at 10% rate of return and operating costs from 100% of plant proceeds. Prior to plant payout over no longer than a 3-year period and 25% thereafter. The revenue split equates roughly to 50% of all plant revenue over the productive life of
Yes,
the plant.
Counselor, you don't have to read through it. I see it. I have your bench book. You don't have to
Well,
read through it.
Thank you, Your Honor. If I may just conclude, in the event field produced volumes fall below levels required to meet the 3-year payout, CDM Max will be due cash payments. That's what this case is all about. We told them this is how this is going to work. We got them, we sent them the form where we acknowledged and we identified that they were going to participate in the gas processing plant, and they agreed to it. They consented to it. And the jury found that. The jury, we conclusively established that they consented. That's the reason they didn't submit an instruction. So if I may, Your Honor, I'd like to go to one last issue that I really feel is important, is that the trial court properly entered judgment against Craft Exploration as a matter of law. Craft Exploration was the signatory to the joint operating agreement and the participation agreement. And the participation agreement is found at tab F in our bench brief. And it says, all rights hereto are assignable by any participant subject to prior written consent from Craft and RPC, now Anchor, not to be unreasonably withheld. Any assignment without prior written consent shall be void. And then importantly, it says, debts or liabilities may not be assigned if they have been segregated from their associated assets. And if they are assigned, then both assignee and assignor shall be equally liable for the entire amount. If you look at tab C again of the Anchor, tab B of the bench book, you'll see that Stephen Craft signed both of those for Craft Exploration. And then he noted, please be advised that we will title the right-of-way and gathering lines separately from the gas plant. Mr. Kraft understood the gas plant was part of the deal. He was consenting to it, and he was instructing Anchor how to title the assets. But what you will not find in this record is any assignment from Kraft Exploration to any of the Kraft operating entities. It doesn't exist. He never made the assignment. As a matter of law, pursuant to the participation agreement, and the court understood this, she entered judgment on Kraft Exploration because it was liable for all of these Kraft operating entities that he kept asking Anchor to title assets in. And we know this because if I look at tab G, you can see proper assignments. Proper assignments from Pickens Financial Group to Yazoo Venture, and a proper assignment from the Rudman Family Trust to Bachtel Enterprises. So, Your Honors, the fact is that Kraft Exploration was liable as a matter of law under its contractual agreements for any liabilities to the parties to whom he had Anchor title the various participation issues, including the gas plant, which he acknowledged was part of the transaction. I think it's important for the court to understand that these contractual terms were negotiated by very sophisticated parties, Mr. Stephen Kraft, and initially Renaissance, and then subsequently Anchor. Each of the 14 joint operating agreements read identically. They consist of strike-throughs and markouts. They were heavily negotiated, and this reflects the contractual arrangement between the parties. At the end of the day, Reader controls. Crimson Exploration, following Reader by this court, found that that the prior material breach is covered by the exculpation provision, and to limit the exculpation provision in any way, shape, or form, separate and apart from this, makes no sense. And they have.
Let me ask you about that, Mr. Johnson.
Yes, sir.
So,
Yes.
Given the language of the exculpatory clause, which says you have no liability unless there is a willful breach.
Yes, sir.
The clause seems to contemplate that it's possible that Anchor can breach the agreement without willfulness. And in fact, that's what the jury found.
Yes, sir.
So what I'm trying to understand is, does the exculpatory clause relieve Anchor from all consequences of a breach, or only from liability for damages when they breach willfully?
Yeah.
Unless they breach willfully.
Yeah, that was the quoted language from Reader that I read to the court. It results from contractual obligations more than a mere breach, but rather, this is the Reader, it requires a breach attended by willful misconduct, to paraphrase. So, Your Honor, the breach had to be with willful misconduct. Otherwise, under the terms of the joint operating agreement, it's not a breach if it's for activities. This was not a gotcha. This was a bargain for situation by the industry to permit people to undertake the role of being an operator.
If that's true, Mr. Johnson,
yes, sir.
Why were questions 1, 2, and 3, or questions 2 and 3 submitted the way they were, without any? I mean, those are just straight failures. Failure to comply with the contract and who breached first, without any reference at all to willfulness or anything of that sort.
Well, because the exculpatory provision says contractually, and the court understood this, if the breach by Anchor is not for willful misconduct, there's no breach. There's no breach under the contracts. And this is not a gotcha. This is an arrangement set forth to encourage people to operate, because it's risky, it's expensive, it's difficult, and, Your Honor, there are built-in protections like written exceptions, audit, and even removal of the operator, all of which at some point or another, various non-ops tried to avail themselves of.
I know you referenced our court's opinion in the Crimson case, but
yes,
if you have some others that you want to bring to our attention that support your position on that, I'd like to see them at your earliest convenience. But the reason I'm struggling with this is because question 4A And question 2 and 3 seem to contradict your argument that there can be no breach without willfulness, because you've got separate questions that say there is a breach, and then another question says there's no willfulness.
Yeah, the way it was submitted was, did Anchor breach? Did the appellants breach? Who breached first? And then the next logical question is, because of the way the contract is, because of the exculpation provision, was the breach, if you found by Anchor, as a result of willful misconduct, to paraphrase? And the jury found no, meaning that you then operate the exculpation provision, and it steps in to remove Anchor's breach. That's the reason we didn't move to disregard. We didn't need to contractually.
So you didn't argue that any of the jury's findings in questions 2 and 3 were immaterial?
No, Your Honor, because as a matter of law, no one disputed that the exculpation provision was going to eliminate. That's the reason the judge entered the judgment on the verdict, because of the verbiage in the contract. So we didn't need to contest those findings, because we had a willful misconduct finding that said we did not act with willful misconduct. Hence, operating the exculpation provision, there's no breach, because Reader teaches us that it goes to the breach. The express language in Reader says it goes to the breach.
All right. Thank you, counsel. Any other
Thank you.
questions from the panel? All right. Thank you, Mr. Johnson, and we'll hear from Ms. Pfeiffer now.
Thank you, Your Honor.
Justice Jewell, if I can start with your question, I think one thing that's helpful to think about in this case is if Anchor hadn't passed along these charges to the non-operators, and it had just incurred this liability, but then it was asking us to pay for it and we refused to pay, then Anchor would be suing us trying to get payment for its liability that it signed up for. So it would be all the more obvious in that posture that it can't use an exculpatory clause to go impose liabilities on the non-operators. The only reason this case may get a little confusing is because it's already deducted those charges that it had properly put on our jibs. And now we're in the posture of plaintiff seeking to recoup the money that was improperly deducted. So when you think about it that way, it's a lot more obvious. The exculpatory clause has no relevance to this kind of breach. So the charge was set up correctly. And most of what you heard from Mr. Miller today is his attempt to redeliver his jury argument. He wants to relitigate breach, and he's done it in the appellate brief by completely ignoring the standard of review and bringing up facts, just as Poisson, that have already been determined by the jury, and that he has not properly presented to this court by raising an issue or preserving anything with regard to the breach finding against Anchor. So they don't get to come here and try to re-argue whether there was consent or not. The jury found that there was a lack of consent when it found that Anchor breached the contract. And their arguments about that fundamentally misunderstand charge practice. We have a broad form breach finding, which means we have a finding from the jury of everything that was supported by the pleadings and the evidence. And the entire theory of the case was that Anchor failed to get our consent for these gas plant construction costs. So we have that breach finding. The best case, if there's any confusion on this, is the Powell versus Hewlett-Packard case. It was actually a decision or a case I handled. The Judge Bland wrote the decision for the First Court of Appeals 10 years ago, and it gets a lot into multiple theories of breach with a broad form finding. I'd like to briefly touch on written exceptions, because that is a key part of this court's decision. And I just want to point the court to our bench exhibit, where we've put all the evidence at tab D, but to highlight for the court that written exceptions is not a magic words test. It doesn't require any kind of special form or language or anything like that. It is a notice standard. And this is a case where Anchor's own corporate representative and project manager admitted it had actual notice of our objection to the gas plant construction costs. So not only do we have the written letter objecting to all of this, but we have their own testimony that was admitted into evidence, confessing that they knew exactly what we were objecting to and why. That's the standard under Paint Rock, and I would urge this court to follow Paint Rock and adopt a common sense, practical standard that says, at least in this case where there is actual notice to the party, that there is a sufficient written exception and that we've established that. And I would urge the court to also look closely at Anchor's brief at page 29, where Anchor concedes that if written exception is found, that the willful misconduct standard in the exculpatory clause does not apply. So this court, by finding that there's a written exception, could reverse and render based on Anchor's confession that the willful misconduct standard would have no application where written exceptions are properly taken. I want to impress upon the court, just in conclusion, that this case is extraordinary. It's very different from a typical fight between a non-operator and an operator. And Anchor's positions are really unique and really egregious. No court has ever held that an exculpatory clause would apply to relieve an operator of liability when the operator is the one that contractually signed up for the liability without getting consent from the non-operators. No court has ever held that a written exception requirement was not met where the operator admitted that it received a written objection to the charges and that it had notice of the objection and believed that the written exception standard was satisfied. So it is hard to overstate just how egregious Anchor's position in this case is. Operators don't get to just go sign contracts and start charging non-operators for expenses that they haven't consented to. And especially the way this case went down, where Anchor was stealthy about it, it kept its contract with CDM Max a secret. It wouldn't show the non-operators when they asked to see the contract and try to understand how these expenses were getting charged. And then it started deducting the capital costs for a $13 million gas plant out of their revenues, where it was hard to see on the JIB because it's supposed to be deducted out of expenses. So it obscured what it was doing. It confessed to the jury that it was doing this. And the easiest path to decision here is to hold that the conduct that Anchor did was deliberate mismanagement without regard for the consequences, and to reverse and render judgment in favor of the non-operators.
All right, thank you, counsel. Any further questions from the panel?
Actually, I do have a further question, and I understand your point about, the confidentiality, but I note that there's a comparison of the written exceptions that shows a quote, appropriate and specific written exception jury approved, and then your client's generic non-specific written objection, which is alleged to have been rejected by the jury. So how do you address that argument? I guess you kind of did just now by saying, well, they obscured information and so we filed a letter objection. Is there anything else that you want to inform the court about in regard to the written objection that was filed vis-a-vis the specific written objection that Anchor contends should have been sent to them?
Yes, I'd be happy to answer that. And just remember, it doesn't have to be either or, it can be both. They're both written exceptions. So the Yazoo 2014 letter that you're referring to, that they included in their bench exhibits, that qualified. It gave Anchor notice of what was being objected to. But that particular written exception was for a totally different charge. So it's not the gas plant construction cost there. That's just an example of one of the non-operators finding something on a JIB that hadn't been consented to and circling it and sending it back to the operator. So that was sufficient. But so is the April 2015 letter, where we've put this in our bench exhibits, where they very clearly said that we're objecting to all the gas plant processing charges. And remember, this was not an isolated instance on one JIB. This was something Anchor started doing month after month. So they needed to be comprehensive and say all gas plant processing charges we're objecting to because we never consented. We never signed an AFE or did anything to consent to these kinds of charges. And then they asked for the remedy, and then they filed suit. And in the lawsuit, that's also a written exception under the courts we've cited, the cases we've cited to the court. The claims in the lawsuit can qualify too. But that 2015 letter, I think, standing alone, is conclusive evidence of an objection that put Anchor on notice of what was being objected to and why it was being objected to. And I'd be happy to answer any other questions. I know that you had a lot for Mr. Millard.
Anything else? All right, thank you, counsel. We appreciate your arguments, and the case of Bachtel Enterprises versus Anchor is submitted, and you are excused, and we'll take a short pause as we await the counsel in the second case.
Thank you.
All right, we are ready to hear argument in number 21-133-CR, the state of Texas versus Lausch. Mr. Curry, you ready to proceed?
Yes, Your Honor, I am.
All right, we will hear from you when ready. And Mr. Russell, you'll be put in the waiting room just briefly.
Okay.
Whenever you're ready.
May it please the court, my name is Alan Curry. I'm with the Galveston County Criminal District Attorney's Office, and I represent the state of Texas in these cases. This is a case in which the state is appealing from the trial court's granting of a motion for new trial. And so I want to preface something that I really didn't brief. And that in a motion for new trial, the defendant bears the burden of proof. And the case law will tell you that a motion for new trial is not self-proving and that evidence must be offered at the hearing in order to support the motion for new trial. Well, no evidence was offered at this hearing. And this kind of gets to the unusual nature of this case, what happened and what didn't happen. But here it's clear that the parties were relying upon juror testimony given in respect to a motion for mistrial that was filed earlier in the cases. And then the trial judge said at the end of the motion for new trial hearing that he was going to read the transcript. He never used the word judicial notice. He never said anything like that. But it's clear that the judge was relying upon what had already been presented before. Plus, the parties seem to have landed upon jury charge error as the essential error, although there are many different things that were argued. But the essential error was jury charge error. And the standard of review appears to be a little different in motion for new trial cases with regard to jury charge error, that you ultimately apply an Almanza analysis, which is a much more legal and less deferential standard of review. So with that.
Before you get to that, Mr. Curry, can I ask
Yes.
you a follow-up question? At what point in the proceedings did the court hear from the jurors regarding the impact, if any, of that case that was attached to the charge? Was that after the punishment hearing or?
Yes, Your Honor.
Oh, okay. And so no evidence at the motion for new trial hearing?
No evidence was offered, Your Honor. It's apparent that everyone was relying upon that juror testimony, and the judge recites that he was relying upon that. I could have put that in my brief. I don't know how that might play with the court. Certainly, if you want to hold a defendant to his burden that he's got to present evidence or ask the court to take judicial notice or something like that, that would be an easy way for me to win. That might not ultimately resolve the dispute that we have, however, and I really wanted to get to the dispute that we did have. So
it seemed like no party in the briefing was challenging the court's consideration of the juror testimony.
No, Your Honor. I mean, certainly if someone had stood up and said, Your Honor, I formally asked the court to take judicial notice of what was presented, during the entire trial and what was presented after the punishment stage. I mean, no one could have or would have objected to that. And it's pretty clear that this testimony was considered and was going to be considered by the court, both with regard to the motion for mistrial and with regard for the motion for new trial as well. I just point that out because this is a motion for new trial in which the defendant bears the burden of proof and for which, evidence must be offered. It appears that evidence probably was offered. This is also a jury charge error case in which it is clear that no objection was made to the jury charge until way after the fact. That would seem to suggest what the standard of review should be from Almanza, that it should be an egregious harm standard of review. I have not argued that. Here, it is clear that no one was aware of the error, including the judge, and it's not really an error in our opinion, but no one was aware of it until well after the fact, after the jurors had already returned their verdict, and the judge turns to the back page of count 2 of the jury charge and realizes what's been attached to the jury charge. So we haven't held the defendant to an egregious harm standard in our briefing. But it should be noted that it's not at all clear that this is necessarily jury charge error. There are cases that say when you attach a verdict form to the end of a jury charge, it becomes part of the jury charge. And we have cited to an older 1975 case in which you attach proposed instructions to the end of a jury charge, that does not become part of the jury charge. The judge says in making some recollections, I'm not sure if they're necessarily findings, but the judge says that these were not part of the instructions of the court. This is a situation in which oftentimes you'll see, especially in Galveston County, I've seen, where the court reporter transcribes what the judge actually says when he reads the jury charge. And this excerpt from Green versus State was not read to the jurors, so it wasn't considered part of the jury charge. The judge points out that counts 1 and 2 jury charges are pretty much the same, and they were pretty much the same. There were 2 essentially identical charges of indecency with a child, and obviously this excerpt was not attached to the end of count 1. So we're confronted with a situation in which there really isn't an objection made, but it's clear that, you know, if we're going to consider this jury charge error case, that a some harm standard should apply. But I'm not at all convinced that this is necessarily jury charge error, because it didn't actually happen as a part of the jury charge.
What's your best case on that? That this is not part of the jury charge? That
the name of the case is a 1975 case I cited called Perkins. Your Honor.
Perkins? Okay.
Yeah, and it's admittedly not directly on point. And Jenkins, which the defense has cited, which I also cited, is also not directly on point. Perhaps this falls a little bit in the middle. This is admittedly a very unusual fact situation, but the basic idea here, Your Honor, this is what we're focusing upon, is we do not believe the defendant was denied his right to a fair trial. The defendant here was being charged with indecency with a child. He requested a spoliation charge based upon the fact that some videotape evidence had gone deleted from a records technician in an interview taken of the mother and the stepfather of the victim by the detective in the case. And there's no doubt about the fact that the police did a poor job in collecting evidence, maintaining evidence. The actual fault of losing of the videotape was the records technician, not the detective. There's also some possible body cam footage, although we're not at all certain that the body cam footage even existed. The defense has taken it that this was necessarily destroyed. We're not at all certain that the body cam footage existed. But for whatever reason, if there was body cam footage, it wasn't downloaded to the records people who would handle those kinds of things. Those were the 2 instances in which, you know, the police may have lost evidence or did in fact lose evidence. One by a records technician and one by someone who was supposed to receive downloads from body cam footage.
Counselor, isn't there another instance of 2 lost cell phones by the
Yes, Your Honor. When the defense moved for their initial request for a spoliation instruction, they mentioned the 2 cell phones. The victim makes it clear throughout her testimony that she had 2 cell phones, one that she initially used, and then she got a new phone. She gave those phones over to her parents with the expectation that they would be turned over to the police, and that's all we know about that. The defense withdrew their spoliation request for that instruction based upon the 2 cell phones, because it's not at all clear that those 2 cell phones ever made it to the police. And the idea being that a spoliation instruction, at least in criminal cases, is supposed to be based upon something law enforcement did wrong. And if a private party, lost or misplaced or, destroyed evidence, that would not lead towards a spoliation instruction.
Counselor, since time is short, can you, directing you to the juror who said that it affected his deliberations, can
Yes, Your
you
Honor.
address your argument in regards to a lack of harm when a juror says that his deliberations were affected?
We don't believe that is sufficient to show harm, Your Honor. Number one, in order to show jury charge error and in order to prevail under Almanza, both under egregious or some harm standard, the harm has to be actual. There has to be some actual harm. And here, spoliation was not an issue before the jury. Bad faith was not an issue before the jury. He said it affected his deliberations, but he did not say it affected his verdict. And the harm is in what verdict was issued. In criminal cases, we only have a general verdict. You just heard an argument in civil cases where a number of different verdicts may be issued by a jury. But here, there was only a general verdict. All the jurors, when polled, said this was their verdict. So that's why
Did the state ask the juror to clarify whether it affected the verdict or the deliberations?
We attempted to ask, Your Honor, whether it affected, was in favor of one party or the other. The juror didn't understand the question, and the judge did not permit further questioning at that point.
So is it also your contention then that since there was no spoliation charge, that attaching this case excerpt does not equate to jury charge error?
Yes, Your Honor. We don't believe that spoliation was an issue before the jury because no spoliation charge was given. If the jurors read this and applied it somehow, there's really no way for them to apply it. They would not know what evidence it was meant to apply to. If they tried to remember the testimony of the witnesses, they might think of something, but they still were not told what a spoliation charge does. Whether it's supposed to be,
I'm sorry.
Whether it's supposed to be adverse inference, is it a necessary adverse inference? Is it a permissive adverse inference? They weren't told anything about how to utilize something called a spoliation charge.
So the only testimony we have then is from a juror who affirmatively said that it did affect his deliberations. Is that right?
Yes. And there's all kinds of things that affect deliberations, both good and bad. Whether you had a good night's sleep, whether you had a good breakfast, the other 11 jurors, the trial court's appropriate jury charge, the evidence, all things affect a juror's deliberations. But there was no indication that this affected the actual verdict issued by that juror or any of the other jurors.
Is there any evidence that
I'm sorry, go ahead, Judge.
Oh, no, go ahead.
I'm wondering how you respond to the argument that the verdict was affected because part of the theory was the poor police work by the officers involved in the investigation, which is tied to the spoliation of evidence issue.
Well, again, spoliation was not an issue before the jury. So what would the jurors have done with the idea that there was poor police work in this case? The poor police work would have been the loss of the videotape by the records technician and perhaps the failure of someone with the police department to download body cam footage when the initial allegations were made. There's not a great deal of testimony about that in the record. That's not what this case turned on, in our opinion. You will not hear the word loss or lost or destroy or destruction or spoliation or delete or deletion. Any of those words, none of them show up within the arguments of any of the trial lawyers. All of the trial lawyers focused on some of the bad police work, but most of them focused upon the character of the defendant and the testimony of the victim and the testimony of the defendant's wife, and also some of the text messages that were given back and forth between the defendant and the victim. These are two indecency with child cases in which it is normal that the typical dispute is over whether one believes the victim or not. And this essentially became a dispute over whether one believed the victim or whether one believed the defendant's wife. This case did not turn on the statements that may or may not have been given by the victim's mother or the victim's stepfather to the police. The victim's stepfather didn't even remember giving a statement, but the police officer, the detective who took it, said he did make a supplemental report, and that he did not see anything different in these two witnesses' statements to him from what the victim had given to the CAC interviewer.
And the juror that claimed that he glanced at the excerpt but did not deeply read it and didn't mention whether or not it affected his opinion, what's your position in regard to harm?
Again, I don't believe that shows harm. Again, the harm always under Almanza cases has to be actual. There has to be some sort of actual harm. And there's no indication that that juror or Juror McElroy either had their verdict affected. They all were polled. They all reaffirmed that guilty was in fact their verdict for both of these cases. And there's no indication from any of these jurors' testimony that this actually changed their mind as to the defendant's guilt or innocence, or even impacted upon that. It may have affected one of the jurors' deliberations, and some of the other jurors may have read it, but there's no indication that this actually had a difference in the trial so as to deny the defendant his right to a fair trial.
Well, then I'm guessing, I'm wondering at this point, because you're saying, would you agree that deliberations affect a verdict in general? I mean, that's the purpose of getting to a verdict, is to conduct deliberations and
Sure.
have deliberations.
Yes.
And that, so under your scenario, I guess what I'm wondering is what would it take? Would it take a juror saying, I would have voted the other way in order to show harm?
No, I don't know. I don't know that I would go that far, because I don't think it is a but-for causation. I thought the guy was innocent, and as soon as I read these last 2 pages, I thought he was guilty. Number one, there's really no way for a juror to have come to that conclusion. But I would not want to say that a substantial right of the defendant has been affected only if the juror would have changed his or her vote. I think there has to be some sort of substantial impact upon the jurors' deliberations so as to prevent them from fairly addressing the issues in this case. Spoliation was not an issue in this case. Bad faith was not an issue in this case. Even the loss or destruction of evidence was not really an issue in this case. The police did a definitely poor job, but the primary thing that people would need to look at, jurors included, in deciding whether or not this defendant did what he did, is whether or not they believe the victim.
Justice Berlio, did you have a question?
No, actually, that was the same question I was going to ask.
Okay, I have one follow-up question, Mr. Curry. So if it is correct that attaching a case excerpt to a jury charge is in fact not part of the charge, is the case excerpt an outside influence or not an outside influence, or does it matter?
I don't believe that it would be an outside influence, Your Honor. And it would appear that during the motion for new trial hearing, the parties, the defense withdrew any reliance upon Rule 21.3F, so-called receipt of other evidence rule. And at the end of her argument, the prosecutor said that this was not evidence. I don't believe this was an outside influence. I have cited to the Najjar case for the general standard of review, but it is also another case in which outside influence was kind of an issue that dealt with a police siren being heard during the criminal trial, and whether or not that affected the jurors' deliberations. And the idea being that the outside influence has to be, and we haven't really briefed this, and if you need us to, I'd be happy to, but the outside influence needs to be something detrimental to the defendant. And then again, I would be turning to, the same idea that this was not detrimental to the defendant. And actually the receipt of other evidence cases, if you look at them, and I can show them to the court if you'd like, there's a lot more difficult things that have happened from the standpoint of the state. And the court still held that this was not something that should allow the defendant relief under Rule 21.3F. And I think it would be even a stronger position for the state in that regard.
All right. Thank you, Mr. Curry. We will hear from you on rebuttal.
Thank you, Your Honor.
I apologize, Your Honor. I thought I was waiting to come.
No problem. We're ready when you are.
Okay. May it please the court. My name is Greg Russell. I'm a criminal defense lawyer in Galveston. And I'm representing Mr. Lausch on appeal. I was not the trial attorney. I did handle the motion for new trial. The primary reason for this is the main defensive, or one of the main defensive theories in the case is that that Mr. Lausch did not receive a fair trial based on loss or destruction of evidence, namely Detective Arredondo's, he testified that he took video statements in the video interview room of the Hitchcock Police Department of the complaining witness, MJ, and MJ's stepfather, Donald Whitworth, and also MJ's mother, Sabrina Whitworth. He testified that he took those statements. He didn't know where they went. He turned them into the evidence technician, and the state at the trial filed a notice of exculpatory evidence stating that the records technician, Lynette Martin, for whatever reason, accidentally lost them or accidentally deleted them. And it was such a defensive theory in the case that the trial attorneys actually were the only ones to call the police officers into the case. And that's, in my experience doing trial work, I can't remember ever calling a police officer to a criminal jury trial. It usually doesn't turn out good. And that's how important this defensive theory was to the trial attorneys in this case, Your Honors, that they wanted to elicit that testimony. They didn't want to just elicit the notice of exculpatory evidence that was filed in the case by the prosecuting attorney, Ms. Agnew and Mr. Harrell. So they would have just left it at that. But, you know, they called the officers to go step by step what happened. And I disagree with the appellant, the state here, that there's some issue of whether there was even a body cam. The testimony from Officer Rodriguez specifically says, I'm 100% sure I had a body cam. And then the prosecutor made a deal about, well, you didn't note it in your report. She said, we always do it. And, you know, in the state's brief, in the appellant's brief, they said that there's no evidence that Officer Rodriguez even had a body cam. I disagree with that. She took the witness stand and said, I know I have it.
Mr. Russell, I have a specific question actually about the record. You know, the state contends that the missing statements did not come up during the opening statement and during the two witnesses' testimony and in closing statements. And do you have some places in the record where you could show us that the missing statements were referenced
In the opening
during
and
the
closing?
trial, during the opening statement? And can you give us those references, please?
Sure, Your Honor. I listed it in my brief. So in the closing well, in the opening and closing, it was mentioned by the defense and and the prosecutors in the case, and I was just looking at it a second ago, I apologize.
So,
Okay.
so that's okay. If you have, I don't know if you have any additional references other than what's in your brief, but we can go back and refer to the brief. I don't want you to have to spend time looking for that.
That's fine.
If
So
you,
I apologize. Yes.
right, okay, if you can address this issue of harm for us, please.
Okay. Sure, Your Honor. So the harm that Mr. Lausch suffered is that after it was discovered that the Green case, and I'll refer to it as the excerpt, was attached to the jury charge, they immediately asked for a mistrial. So I don't think Almanza standard applies for egregious harm. He has to show that he suffered some harm because Mr. Lausch, brought it to the court's attention and objected and asked for a mistrial at the earliest possible opportunity, which was, he couldn't object to it during the jury charge conference. He didn't know it was attached. Nobody did. So Mr. Lausch did object to it at the very first opportunity that he had. The some harm that he suffered, Your Honor, is even though the court denied the spoliation charge that the trial attorneys were asking for, the trial court specifically said that doesn't prevent any party, whether it's the state or the defense, from arguing that, they lost the evidence, we were harmed by that, or vice versa for the state. And that's exactly what they did. Even Ms. Agbu, the prosecutor, in her closing statement said that the Hitchcock Police Department did a terrible, horrible job. Both the defense attorneys, Mr. Barnett and Mr. Burns, both stated that, the loss of this evidence is harmful to us. But then when the jury gets the excerpt from the Green case saying, unless the defense can show that it was destroyed in bad faith, basically, with animus towards the defendant, then there's no due process violation. So here you have the defense arguing.
Hey, Mr. Russell, can I interrupt you there real quickly? So is that the particular language in the Green excerpt that you're contending caused the actual harm?
Well, the Green case, Your Honor, is very, very similar to Mr. Lausch's case. You have a guy named Hall that gave two statements. One of the statements was lost or destroyed or whatever. They couldn't find it. So then he changes his story to the second statement. The first statement was lost. But so Mr. Lausch, he's arguing, Mr. Lausch's defense attorneys is arguing to this jury, ladies and gentlemen, my client didn't get a fair trial. We have three statements of witnesses that were lost. We have a body cam that's lost. And, so they were arguing this. And then they get the Green excerpt, which, basically says that, you have to show bad faith on the part of law enforcement. And so the one juror that was, Mr. McElroy, he, the trial judge brought all the jurors in, all 12 of them, asked them what they saw, if it influenced their deliberations, their verdict. Mr. McElroy specifically said, do you mean me as individually or as a group? And then the court said, you individually. And he says, yes, it did influence my deliberations and valuation of the case. And for the state, for the appellant to say that Mr. Lausch suffered no harm is, I think it's obvious that he suffered harm, Your Honor. By my calculations, 6 jurors read the excerpt. 11.
No, but my question, Mr. Russell, is what specific language in the 2-page excerpt is the language that you contend is troublesome?
Okay, so Your Honor, in the excerpt, it specifically says, it says bad faith requires some showing of some sort of improper motive, such as personal animus against the defendant or a desire to prevent the defendant from obtaining evidence that might be useful. And then it goes on, having concluded that the trial court did not err when it denied appellant's request for spoliation, well, the jury didn't know that that was being requested, but I mean, the case specifically says, spoliation refers to the loss or destruction of evidence. Failure to preserve the evidence does not constitute a violation of due process. Bad faith requires simply more than being aware. You have to have an improper motive. So, when they read this, well, we just heard the defense attorneys argue, that Mr. Lausch didn't get a fair trial because, 3 witness statements were lost and a body cam was lost. But here's something attached to the charge from the trial judge saying no harm, no foul, basically. It cuts against the defensive theory. The jury is the exclusive trier of the weight to be given to the evidence. Even that's why the trial judge, Judge Ellisor, specifically told both parties, the state and the defense, y'all can argue away. Y'all can argue away as to how it hurt your case or whatever. And that's exactly what they did. But then they get an instruction from the judge, and they're presumed to follow the judge's instruction. And so the state, Your Honor, also made a big deal about, well, Mr. McElroy simply said it affected his deliberations. He didn't say that it affected his verdict. But
if the jury had been given a spoliation instruction that the defense requested, what would it have said?
Well, it probably would have said stuff consistent with the Green case, Your Honor. That, you'd have to show bad faith on the part of law enforcement, personal animus towards the defendant, not mere negligence in losing the evidence. But back to, so, the state wants to say, well, he didn't say verdict, that it affected his verdict. A juror doesn't know the difference, Your Honor. He doesn't know the difference between verdict and deliberation. He probably, most lay people that, aren't acquainted with the law, they probably think it's the same thing. But those were the questions that the prosecutor in the trial, Mr. Harrell, specifically wanted the trial judge to ask. He said, we need to ask these jurors whether it affected their deliberations. And then they want to complain, well, he didn't say verdict. Well, those are the questions that the state chose to ask. And in my view, Your Honor, and I think it's reasonable that, a lot of the jurors, they don't know the difference between deliberation and verdict. It affected his valuation of the case, is what he specifically said when Judge Ellisor asked that question. But he was originally only going to call Mr. Juror Cambiano out, who was the foreman. And then Cambiano said that, it was passed around, it was put on the overhead. And then they started bringing them out and they were getting divergent stories. I mean, it was all over the place. Some people said it was put on the overhead. Some people said they read it, but it didn't influence their verdict. Some people said it was passed around.
So, Counselor, in a circumstance where we simply don't know what's in the juror's mind and how they interpreted it, where do you find the harm?
I'm sorry, Your Honor, where do I find harm?
Yes.
Well, Judge, in my view, the harm is it's a defensive theory that they've been arguing this whole trial. They actually had to call 2 police officers to establish this theory, and they're arguing it in their closing. They're arguing it in their opening. They're hammering it throughout the whole trial.
Well, I have another question about that, actually, which is, you said in closing statements, they talked about the lost statements and the loss of evidence.
Yes, Your Honor.
Were they that specific about that it was the statements that were lost? And
yeah, so the defense basically said, Officer Rodriguez lost the body cam, Detective Arredondo lost 3 witness statements. Both Burns and Barnett, both defense attorneys, because they split up their closing, drove that into the ground. And then Ms. Agbu also stated in her closing, yes, they did a horrible, terrible job. Those are her exact words. So, and then in opening, the defense also said, there's going to be things in this case that you'll find that the officers lost, specifically statements. So it was a defensive theory throughout the whole case, that Mr. Lausch did not receive a fair trial based on law enforcement's destruction or negligence, or however you want to phrase it. But the point is it was a defensive theory. And then this cuts against the defensive theory when the trial court accidentally, and it was obviously an accident, attaches a case saying, unless you can show that it was done, with bad faith intentionally, there's no due process violation.
And in regard to the standard that you're espousing that we use, it should not be on Monza, it should be some harm. And is that what your brief says?
Correct, Your Honor, because the defense during the jury charge could not object to it because it wasn't read. Nobody could object to it, the state or the defense. And since the defense objected to it at the earliest possible opportunity, then they satisfy Almanza, and the standard of jury charge error should be some harm. And I think it's obvious, even if one juror, Your Honor, says, it affected my deliberations, it affected my valuation of the case. Even if one says it, that's some harm.
All right, thank you, counsel. Any further questions? All right, thank you, Mr. Russell.
Thank you, Your Honor.
Mr. Curry, you have 5 minutes.
Thank you, Your Honor. So looking at what happened in this case, the judge attached, after arguments, after the reading of the jury charge, 2 pieces of paper to one of the 2 jury charges. There are situations in which trial judges make erroneous jury charges. They give erroneous instructions within the jury charge. And I guess something that I didn't mention in my first part of our argument that I'll mention now. These 2 pieces of paper, if we're to raise them to the level of an actual instruction, were nothing more than abstract. And the case law is clear that an error in the abstract portion of the jury charge doesn't necessarily mean, even under some harm standard, that the defendant's rights were violated, that his substantial rights were affected. I'm
wondering, Mr. Curry, in any of the case law that you cite in your authority, has there been a circumstance where a juror has said on the record that it affected whatever was attached to the charge affected his deliberations?
No, Your Honor. This is a very unusual fact situation. I mean, usually when this type of testimony is presented or offered, we would object under Rule 606B. And I'm not certain that this was admissible under Rule 606B, but we didn't object to it. We frankly wanted to get to the bottom of whether or not the jurors had any effect. But none of the jurors, including Juror McElroy, believed or testified or had the inclination that this actually affected their verdict in this case. Now, we didn't ask all of the questions, as pointed out by Mr. Russell. We didn't ask a lot of questions of any of these jurors. They testified rather rapidly. But an overall view, including of Juror McElroy's testimony, is that this did not affect the verdict.
Well, we don't, Mr. Curry, with all due respect, we don't know whether or not it affected the verdict because he used the word deliberations and no one asked that question. I mean, that's.
Well, that is true. We don't know for sure. But again, we have to show actual harm here. We have to show that something actually was done that turned these jurors. And these 2 pieces of paper were not something akin to have done that. The Green case was very different from this case. The Green case was a case in which 2 statements were given. One statement was lost, and apparently, one was very different from the other. Here we have a case in which the caption deals with a spoliation instruction. The caption of that portion of green that was presented to the jury dealt with the spoliation instruction. The jurors weren't told what a spoliation instruction was. It's mentioned in there, it deals with the loss or destruction of evidence. No one argued loss or destruction of evidence. You won't find any of those words in any of the arguments of any of the lawyers. This was not an issue for the jury to decide, either by way of an instruction from the court or by way of argument of the lawyers. The horrible job that Ms. Agbu pointed out that was done by Detective Arredondo. She singled him out as having done the horrible job. Detective Arredondo is not the one who lost this evidence. It was a records technician who lost it. Ms. Agbu points out that Detective or Officer Rodriguez could have done a better job, and there's no doubt about that as well. But Officer Rodriguez is not the one who lost the body cam footage. She testified that it's downloaded automatically, or it's supposed to be downloaded automatically. So either there was assuming that there was body cam footage, either there was a technical glitch whereby it wasn't downloaded correctly, or someone in records made a mistake.
So could you give us an example of what would rise to the level of some harm here?
What would rise to the level of some harm would be if this instruction actually told the jurors what to do. You know, Watts is an egregious example that I've cited in my brief, where the judge actually attaches something that is directly on point with, you know, the highest court in the state, essentially telling the jurors what to do in a water pollution case on the specific issue in this specific case. Here, the jurors aren't told what to do about anything.
So under that logic, then, if the excerpt had been attached directly told the jurors what to do with a specific issue, and the jurors testified that it did not affect their deliberations, would that still rise to the level of some harm?
It could, depending upon what the case said, Your Honor. I mean, if it was a closer analogy, maybe it might have. I'm not even certain of that, because, you know, this would get into the question of whether this is jury charge error. But assuming that this case talked about, you know, videotape evidence that existed and was lost, and it impacted upon the actual victim's, you know, case. For example, if this was videotape evidence of the victim, and akin to the Green case, it was the missing testimony or the missing statement or the missing video was actually helpful to the defendant, or actually would have heavily impeached one of the state's witnesses. We don't have any indication of that which was lost was in any way even impeaching, much less exculpatory. The officer testified that what the victim's mother and the victim's stepfather told him was essentially consistent with what the victim had told the CAC interviewer. There's no indication that what was told to Officer Rodriguez at the initial meeting with all the parties was in any way inconsistent with what the victim had told. There are inconsistencies in the victim's story, but those were brought out before the jury. You know, they were presented to the jury, where she didn't tell everything to the CAC interviewer that she did tell to the jury. And then she didn't tell everything to the police that she ultimately ended up testifying to. There's no indication that any of these statements were inconsistent, or that they were in any way exculpatory or impeaching. And therefore, we don't believe that this rises to the level of some harm.
I do have another question, Mr. Curry. I note in the record that the trial judge said about the charge that he presumed that when the court instructs them, meaning the jury, and gives them a charge, they read it. And I encouraged them to read through the entire document when they went back to deliberate. So I'm assuming it can have, you know, a high degree of confidence that they read that document. Do you agree that the trial judge encouraged them to read through the entire document?
I mean, he said that, Your Honor. I don't remember reading him saying that, and I wasn't able to find it in the record. If we are to construe what the judge did there as a finding I'm not sure he was attempting to make a finding.
Well, and before
I
you
would-
continue, let me tell you where it is. It's in one reporter record, pages 10 and 11, just so
Like-
you'd like to look at it, you can.
Yeah, I know what he said. I don't remember him actually saying it to the jurors. But if he did say it to the jurors, I would respectfully contend to the trial court judge that his finding is not supported by the record, because the jurors actually testified, and many of them, most of them, in fact, said they didn't read it. I know some of them were wishy-washy about that, but most of the jurors said they didn't read it. Now, the judge said he encouraged them to. The judge believed they would, but if that is to be construed as a finding, and I'm not so sure that it should be, but if it is construed to be a finding, it's not supported by the record, because most of the jurors didn't read it as they testified.
Any further questions? All right, thank you, Mr. Curry.
Thank you, Your Honor.
And, thank you, Mr. Russell, if he joins us again.
Yep. Thank you, Your Honor.
Thank you, Mr. Russell. Thank you for your arguments.
Sure.
The case of the state of Texas versus Lausch is submitted, and counsel are excused and will be adjourned.
Thank you, Your Honor.